It's 12:06 on Tuesday, March 25th. The House Criminal Justice Subcommittee is now in session. Madam Clerk, or members, let's take the roll. All right. There we go. Madam Clerk, please take the roll.
Mr. Chairman, you have 7 members present. You have a quorum.
Thank you very much. Members, personal orders before we begin. Representative Powell.
Thank you, Mr. Chairman. It's HIV Awareness Day on the Hill, so I wanted to recognize those that are here from the community supporting HIV. I'm proud to have Nashville Cares in my district that serves that community here in Nashville, but want to recognize everyone who's here on behalf of the HIV community. Thank you.
Yes, sir. Thank you. Representative Ashley.
I'd just like to welcome our chiefs and sheriffs that's here with us today. Look like had a whole hallway full of them out there. I'm looking for them right now. Raise your hand if you're just like to welcome y'all here today.
We have any other personal orders? Representative Salinas.
I just wanted to recognize 2 groups, Moms Demand Action, who's here advocating for common gun sense laws, and then Rocket Ship Public Schools, who's here advocating for our public education.
Anyone else need to be recognized? All right, we'll go to our Sergeant of Arms, Mr. Tyler Muniz, for the weekly words of wisdom.
Good afternoon, everyone. Today's words of wisdom are inspired by Rep. Carringer's Blaze Pink TWRA bill. They are brought to you by Cyndi Lauper. That's all they really want, some fun. When the working day is done, you know girls, they want to have fun.
Thank you.
I'm so honored and so blessed. Thank you, Chairman
Well,
Doggett.
thank you. Thank you for coming down here and being with us to let us do that. Yes, ma'am. All right. So we're in a new committee room this week, or at least for today. I think we'll be back in our normal abode tomorrow morning at 9 a.m. So bear with us as we work through some of the technical things of getting microphones working and everything else. A lot of bills on the calendar. This is our final calendar. The amendment deadline was yesterday at noon. So if you have late filed amendments, good luck. Item number 9, House Joint Resolution 176 by Chairman Vaughn will be off notice. Item 10, House Bill 1116 by Rep. Carringer, off notice. Item 14, House Bill 723 by Representative Fritz, off notice. Item number 17, House Bill 1081 by Leader Camper, off notice. Brings us to item number 1, House Bill 850 by Representative Renaud.
Thank you, Mr. Chairman and committee. HB 850 addresses an issue. Oh, pardon. Oh, just kidding.
There you go. You're recognized.
Thank you. HB 850 addresses an issue that we are all aware of, and many of our colleagues over the years have desired to address. It's about protecting private property rights of Tennesseans. Currently, government agents can enter, search, place cameras, and collect evidence on my land without my consent or a warrant. I, as well as 99.9% of Tennesseans, think this is wrong and believe that agents should get a warrant before doing these activities. Recently, the Tennessee Court of Appeals concluded in the Rainwaters versus TWRA case and determined that their warrantless entry onto a person's private land is unconstitutional. And in my view, the court's reasoning should apply to all private lands in the state as well as to all agencies. The intention of this bill is to require government agencies to comply with the best practices already undertaken by law enforcement, who also obtain a warrant before entering private land, except in cases where well-established judicially recognized exceptions apply, including, but not limited to, exigent circumstances, hot pursuit of a criminal, plain view doctrine, or warrantless and non-criminal entry onto private land or property where the agent's discretion is limited, such as your property assessor or your meter reader. Currently, there are 0.01% of people who have concern about this bill, and those are the government agencies and departments that do work on behalf of Tennessee, which is why I'm asking to roll this bill to the 1st of 2026 so that we can work further with them to hone the language or potentially investigate needed processes to allow them to do their job, but also so we can figure out where we must draw the line to keep Tennesseans free from government intrusion without due process.
Thank you for that explanation. Leader Lambert.
At the request of the sponsor, make a motion to roll to the first calendar of next year, and I hope that we do focus on this in the off season.
All right, there's a proper motion. It has been seconded. Any objection? Seeing none, House Bill 850 will be rolled to the first calendar of 2026.
Thank you, Chairman and Committee.
Thank you. Item number 2, House Bill 785 by Chairman Howell. You are recognized.
Thank you, Mr. Chairman and committee. Members, House Bill 785 is a reporting bill. It's designed to ensure that bail bonding companies are not overextended on the amount of bonds that they are approved for. An example would be if a bonding company is approved with a letter from a bank, for example, for $1.5 million. Currently, it's very difficult to find out if they are overextended. So like maybe $2.5 million. This bill purports to correct that. Under current law, the bail bonding industry self-reports. However, a bondsman may be licensed to do business in 1, 2, 3, or 4 counties, but a judge in one county may not know, since it is self-reporting, they may not know what a bonding company is obligated for in another county. So this bill is designed to correct that. That's the first thing the bill does. The second thing the bill does is the bond, every bond that is written contains a $12 fee, which is submitted to the Department of Revenue. That's current law, by the way. This bill creates an audit process and gives revenue working with information from the court clerks the ability to determine if that $12 fee is paid on each bond. And that's what the bill does. I ask passage.
Well, thank you, Mr. Chairman. There's an amendment I should have asked you
There
about
is.
to start with, Amendment Code 4914.
That
All
is
right.
correct.
That amendment, does it make the bill?
It makes the bill.
All
yes.
right. Without objection, we're now voting to adopt Amendment Code 4914 on the House Bill 785. All those in favor say aye. Those opposed, the ayes prevail. You adopt or own your bill as amended, and you have explained the bill
Yes.
as amended. Questions for the sponsor, Leader Lambert?
Move previous question.
Question's been called. Any objection? Seeing none, we're voting to send House Bill 785 as amended on the full judiciary. All those in favor say aye. Those opposed? Never mind. You got to vote on the board. You got ahead of myself. Anybody wish to change their vote? All right. Madam Clerk, take the vote.
Mr. Chairman, you have 7 ayes, 0 noes, and 1 present not voting.
The ayes prevail. House Bill, 785 is amended, moves on the full judiciary.
Thank you, Mr. Chairman and committee.
Yes, sir. Thank you. You revert back to old habits when you get to rolling sometimes. Item number 3, House Bill 883 by Chairman Todd. He is not in the room, so we will roll him 5 spaces. Item number 4, House Bill 661 by Chairman White is not in the room. We will roll him, or Leader Lambert.
Mr. Chairman, he is over chairing full education right now. Could you potentially roll him to the Hill? And then if Mr. Chairman, if you were to walk in, potentially take him up at that time?
We'll take care of him. We'll roll him to the Hill.
Thank you, Mr. Chairman.
Item number 5, House Bill 445.
Motion.
Chairman Halsey, you're recognized. You have an amendment code 5985. You wish to proceed with that amendment?
I'd like you to put it on the bill, please, if you would, because it makes the bill.
All right. You're recognized on the amendment. Any objection to the question on the amendment? Seeing none, we'll vote to adopt Amendment Code 5985 on the House Bill 445. All those in favor say aye. Aye. Those opposed? The ayes prevail. You adopt. You wish to be recorded as no. See the clerk. We're on your bill as amended.
Thank you, Mr. Chairman. Thank you, committee. Last year, we had several bills that came through criminal justice dealing with the issues of establishing a system that voting rights could be restored. And because we'd put different things in state law at different times, there were places that it seemed like they were not just convoluted, but almost antithetical to each other. And so I must say thank you so much to Michelle Fogarty, who spent half the summer and half the fall researching all of this and coming up with a voting right bill that establishes continuity and does away with some of the problems that we had before. Some judges were reading that citizenship rights were the same as voting rights, that they couldn't be separated. Some of them were reading that if you couldn't get all of your citizenship rights back, you couldn't get any of them back. And so we set about to fix those problems. And so at the end of the day, we have this bill, and it does fix those things. It revises the process for restoration of rights of citizenship by creating one process for everyone seeking restoration of rights. And under current law, or we have right now, there's one process for persons convicted after July 1st, 86, but before July 1st, 96, which requires only the completion of a form by a supervising authority. And then under current law, there are separate processes for persons convicted on or after July 1st of 96, which requires them to file a petition with the court and provide notice for the district attorney, and the court then decides whether to grant restoration. Those are some of the problems that we were having and some of the things that got straightened out in this bill. So what does this bill do? Well, it doesn't change the fact that some folks can never regain their voting rights. If you have committed murder, rape, treason, official misconduct, sexual crimes against minors, or voter fraud, you can never get your voting rights back. This bill doesn't change that. That's an existing law. What is also an existing law is the person must have paid any restitution ordered by the court, the person must have paid court costs, and the person must be current in all child support obligations. That didn't change either. That's existing law, and that stays in this bill. What this bill does is streamlines the process for restoration of voting rights. It separates voting rights out where you can get them when you can't get any of the rest. For individuals who have a previous felony conviction, this bill establishes a judicial process for restoring the person's voting rights that does not require the person to regain their full rights of citizenship, as I just said. The process is same for everybody. Doesn't matter what right you're trying to get back or earn back. The process is the same for everybody. They all have to go in front of the court to get that done. The bill recognizes that the courts can restore certain, I said that. This bill also defines the phrase court cost to specify what costs must be paid by a person to have voting rights restored. This bill clarifies that voter fraud means a felony offense under Title II, Chapter 19, which is current. Voter fraud is a permanently disqualifying felony of those that I mentioned before. The bill changes the presumption that citizenship rights are to be restored and requires the petitioner to show the court by a preponderance of evidence that the citizenship right should be granted. That is new, but it is not necessarily an onerous thing, because included in this bill also allows a judge, if these items are submitted that shows that he's completed or she's completed what needs to be done, he doesn't have to have a hearing. He can go ahead and sign off. It doesn't require for them to show up for a hearing. This bill requires notice of a petition to restore citizenship rights to be given to the Attorney General and allows the Attorney General to object. Previously, only the district attorneys and the U.S. Attorney were given notice of these proceedings, but we added the Attorney General in that process. And the bill directs the administrative office of the courts to develop a form which can be used by petitioners in the courts in this process. So there'll be one form. It'll go one place. It'll go to the county that the petitioner lives, or it'll go to the county where the crime was committed. And it'll go in front of Chancery Court there. Here's an example. John Doe must have his citizenship right restored by a circuit court. I'm sorry, circuit, not Chancery. Where he lives or in the county where the conviction occurred. In this petition, Mr. Doe will demonstrate to the court that he's paid any restitution owed, that he's paid the court costs as defined in the bill, unless the court makes a finding that he is indigent and that he does not have any outstanding child support obligations. The DA or the U.S. Attorney get notified, as well as the coordinator of elections, and the judge can sign off on that petition, and he will receive his right to vote again. That's pretty much all of it. There are some folks here to speak against the bill. I know that, and I'm at your will on how you want to do that.
All right. Thank you very much. I do have a member on the list, but we've got testimony. You want to wait? All right. Thank you. All right, members, we'll go out of session. And what we'll do is I think I've got enough seats for everyone here. Charles Grant in the building. Okay. Keita Haynes. Dawn Harrington. Amy Pruitt. Crystal Turner. You're welcome to have a seat. What we'll do is we'll start on to my right, and we'll work our way back down this way. If you will, introduce yourself for the record. You'll have 3 minutes for your comments. We'll go one at a time, and then we'll open it up to the committee like it's a panel or something. So.
Is it on?
You're on.
Okay. Good morning, Chair Doggett and members of the committee. Thank you for the opportunity to speak today. My name is Amy Pruitt. I live in Franklin, Williamson County, Tennessee. I'm a legal assistant and have worked in Nashville law firms for the past 15 years. I am the legal assistant to attorney Keita Haynes at Free Hearts Organization. I'm here today in opposition of this bill, but first I would like to thank Representative Hulsey for all of the hard work that he has put into this bill, especially the separation of gun rights from other restorable rights. However, the remaining parts of this bill will ultimately make it more difficult for people with a felony conviction to vote. I've worked alongside attorney Keita Haynes to prepare petitions to help people restore their citizenship rights. In my role, I've seen firsthand the confusion and complexity surrounding this process. And I have also worked directly with individuals struggling to navigate this convoluted process. Since the voter restoration process changed from the certificate of restoration to now having to file a petition to restore rights of citizenship in court, along with the Elections Commission requiring gun rights to be able to be restored in order for your voting rights to be restored, has brought much confusion. Judges are confused. Court clerks are confused. Court clerks are inadvertently giving out incorrect information, as well as county elections commissions. I've witnessed all of this myself. Judges have referred pro se petitioners to Attorney Haynes. District attorneys have also referred pro se petitioners to Attorney Haynes. Marshall County, along with some other counties, have also contacted us for guidance on how to handle these petitions. We currently have a client whose paperwork from over 10 years ago has been lost by the probation department. They have no record of our client. He cannot go forward without this proof. He cannot get his voting rights because of this. These are just a few examples of how complex and confusing the current system is, and this bill, other than the separation of gun rights, will make this harder for petitioners. HB 445 adds more barriers, forcing individuals to prove additional requirements, increasing the burden of proof, and requiring even more documentation. It changes the presumption that a petitioner's petition will be granted to having to show a preponderance of evidence that their rights should be restored. Many of our clients have very old convictions. Many of our clients have a hard time even showing merit. Often clients ask me, how do they show merit when they just go to work and go home and pay taxes? What else do they need to prove to get their voting rights back? These changes.
I'm sorry, our 3 minutes are up on that, but we'll move to the next. You may have an opportunity for questions or whatever.
Good afternoon, Chair Doggett and members of the committee. Thank you for allowing me the opportunity to speak today. My name is Keita Haynes, and I am the Senior Legal Advisor at Free Hearts, where I represent individuals with felony convictions in restoring their citizenship rights, including their right to vote. I've also been working to train volunteer lawyers on this process through a project created by the Tennessee Supreme Court's Access to Justice Commission. Prior to July of 2023, my clients who wanted to restore their voting rights needed my assistance to complete a certificate of restoration and to bring this form to their local elections commission. This was a free administrative process. This all changed in 2023 when the Supreme Court in Falls v. Goins read our statutes as creating a two-step process to restore the right to vote. Individuals now must file a petition in court to regain full rights of citizenship and then bring the court order with the certificate of restoration to their local elections division. 6 months later, the elections division made the unprecedented decision to restore full rights of citizenship, including restoring gun rights. So individuals with felonies that permanently barred them from possessing a firearm could never satisfy the first step, and as a result could not be restored to vote, even if their court order literally stated that it restored to their right to vote. Sections 1 through 5 of this bill fixes the confusion created in 2023 by making clear that restoring voting rights is separate from restoring gun rights. And while I appreciate Representative Holsey's efforts in Section 1 through 5 of this bill, the rest of the bill creates new and unnecessary barriers that make it even harder for people to regain their voting rights. It is because of these new barriers that I must oppose HB 445. Currently, under the statute, there is a presumption that full rights of citizenship will be restored upon sentence completion and justification for restoration, and only the district attorney is notified. Under the statutes in 4029, 200 through 204, a completed certificate of restoration is sufficient proof of eligibility to register to vote. No additional standard or documentation is required. This bill, however, imposes a new preponderance of the evidence standard, shifts the burden onto individuals to prove eligibility, and requires notice to 3 separate state entities. The bill also mandates sworn statement, which has never been required, and these changes make the process more complicated. A simple petition by the AOC and the Secretary of State will not resolve these issues. Furthermore, given the number of people disenfranchised, concerns have been raised about the efficiency of this process, particularly in rural counties where judges are only present every 6 to 8 weeks. Court clerks will face challenges in managing the increased caseload, as well as district attorneys who are already overworked and understaffed in most districts. Most importantly, individuals fear they won't be able to navigate the process, especially if they can't afford an attorney. But there are options. One is an amendment that includes sections 1 through 5 to make clear that restoring voting rights is separate from gun rights, and keeping 4029-202.
We hit our 3-minute mark.
Okay.
Good morning, Chair Doggett and members of the committee. My name is Dawn Harrington, and I'm a resident of Jackson, Madison County. I'm here to ask you today to vote no on House Bill 445. Last year, when the voting bills were sent to summer study, I was hopeful that there would be a real opportunity to engage with those of us who've been doing this work for years. Across literally every county in Tennessee, we've been helping people navigate the confusing, often broken system of voting rights restoration. I had hoped that we would be able to testify, bring our data and information, and be brought in as real collaborators, and that we could use our direct experience to craft a policy that works in practice, not just on paper. Instead, this bill adds more procedural barriers rather than removing them. In 2020, I was able to vote for the first time after my incarceration, but let me be clear, it took me 9 years to get there. 9 years of navigating a system that was already too difficult to understand, and that was under the old process. I never thought it could get worse than what I went through, but this bill proves me wrong. If I, with resources, connections, and advocacy experience, struggled for near a decade, how much harder will it be for someone without those advantages under this new bill? And I'm not alone. Just in 2022 and 23, we had 2,705 people reach out to us, including several from each of your districts, desperately trying to figure out how to make it through the process. We have worked tirelessly to guide them, and yet barriers remain overwhelming. We do need a new process, one that simplifies and streamlines restoration, not one that creates new obstacles. I want to ask, why should the burden of proof be on the person who has already done so much to reintegrate into society? They have served their time, completed probation or parole, and are working hard to move forward. Why did they have to prove they deserve their fundamental rights back? This bill puts the responsibility on the individual to navigate a complicated system, even though the state has the records that are needed to determine their eligibility. If the government took away the right to vote, then the government should be responsible for restoring it, not the individual who has already paid their dues. It also expands court costs to include fines, which was not the case before. Lastly, I want to be clear. I agree with separating voting rights from gun rights, but voting is a fundamental right, and it should not be left to the discretion of the courts. No judge should have the power to decide whether a person can participate in the democracy. The right to vote should be protected, clear, and accessible to every eligible citizen. House Bill 445 moves us in the wrong direction. Instead of passing this bill, I urge this committee to engage with the people most impacted, those of us who have lived this process, who knows where it fails, who want to fix it the right way. For these reasons, I ask you to vote no on House Bill 445. Thank you.
Thank you for that. You're next.
Good afternoon. My name is Crystal Turner, and I'm from Gallatin, Sumner County. I'm here today to oppose this bill. I want to share my personal experience to highlight why Tennessee's voting rights restoration process is flawed and why we need a more streamlined, accessible system. When I was 19, I was convicted of a felony drug offense in Texas. I paid my dues, completed all legal obligations, and successfully went through the certificate of restoration process and was able to vote in Texas. I moved to Nebraska in 2018, was able to vote there with no issue. When I relocated myself and my business to Tennessee in 2024, I was told I couldn't register to vote. Actually, according to the present laws, I've lost all citizenship rights despite having them already had some of them restored in another state. Tennessee's complicated and confusing process prevents me from participating in my most fundamental civic duty. It's like I'm being punished all over again for a mistake I made when I was a teen, one that I have long since taken responsibility for and moved beyond. This bill would only make this broken system even worse. Instead of adding more barriers and delays, Tennessee should be working toward a process that is clear, fair, and consistent with other states. People who have already gone through the rights restoration process elsewhere should not have to start over from scratch just because they choose to move here. I urge this legislator to reject these bills and instead work towards a voting rights restoration system that is efficient, transparent, and respects the progress people have made in rebuilding their lives. Thank you and God bless.
Thank you very much for your time and comments. First on my list is Leader Lamberth.
Thank you. And Chairman Halsey, wherever you went, I appreciate you bringing this bill. He spent 6 months trying to work on this. And I just want to thank all of y'all. I've met with virtually everybody here, and y'all are passionate advocates for both your clients and for those that are trying to get their voting rights back. I mean, these are folks that obviously have committed felonies, but there should be a pathway back to reentering society. So I think this is a good step forward. But I just want to say publicly, I appreciate all of y'all's efforts. You fight very, very passionately for the folks in this state that are convicted felons that are trying to get their voting rights back. So just wanted to publicly say thank you for that. And y'all hadn't been in my office a lot this year, so I assume you were down the hall in Chairman Halsey's office. So, but thank y'all for your work.
Representative Salinas.
Yeah, my question is for Ms. Haynes. I've been trying to follow this very convoluted thing. So could you explain the process for getting your voting rights restored previously before the Falls versus Goins case?
Yes, thank you for that question. So before the Falls v. Goins case, it was just a certificate of restoration that people had to fill out. And they took that form to TDOC, the Tennessee Department of Corrections, and the Tennessee Department of Corrections would fill out that the person had paid their court costs, so court costs had been waived. They would also fill out the part to say that they had paid restitution if they owed any restitution. And then the form would then go to the Elections Commission. The Elections Commission would contact the DHS to see if the person had any child support and if they owed a rearage. If not, then the person would be registered to vote. It was a free administrative process.
Okay, thank you. So that process didn't involve the court in comparison to what is being proposed. Is that?
So before 2023, the court was not involved in getting your voting rights back. The court was not involved with getting your voting rights back until the summer of 2023, when the court issued Falls v. Goins. And that is when the court said that it is a two-step process in order for you to get your voting rights back, that you had to first go to court to get your full rights of citizenship restored and then do the certificate of restoration process. So that is what we are looking at now, is a two-step process. And I would say that as far as that first process is concerned, it is not as simple as what Representative Halsey read out to you all and made it to see that it's just steps 1, 2, 3. Like, it's, the statute may read that, but in reality, when it comes to doing that, it is absolutely not as simple as that. And adding all of these other things that this bill does, it makes it so much harder and so much more confusing and convoluted for people to get their rights restored.
And why did the process move out of the court?
So the process was moved out of the court system in 2006. And in 2006, if you go back and if you even listen to all of the legislative history around that, one of the main reasons that they wanted to do this is because of the fact that people were having to go back to court. It was a burden on people to actually have to do this and to go to court. And one of the main things that they talked about was the fact that people have to pay a filing fee in order to go to court, and that is a poll tax. And that was one of the main concerns with taking it out of the court system, making it an administrative process, and making it a free process, because they understood that this is a fundamental right and you cannot charge people in order to get your right restored. So that's why it was moved out of the court system, to make it a process that was streamlined and more accessible for a lot of people than what it had been going through the court system.
One more. I'll make it a good one. So in your opinion, this new court-only process, is it more difficult?
It's difficult now, and this bill here will make it even more difficult, with changing the burden from presumption to preponderance of the evidence, requiring folks to have to do sworn statements, having to give notice to not just the DA, but also to the AG's office and the Secretary of State, which does carry financial, person has to pay to serve somebody in civil court, right? So it was $45 when we did it down in Lewis County. So 45 times 3 plus the filing fee that people are going to have to waive, right? Like, all of these extra things that people have to do. And then the question becomes, is that, well, how do I serve the AG's office? How do I serve the Secretary of State, right? Like, clerks were even concerned, you know, oh, well, do I serve this DA? Is it this DA in this county? Is it this DA in that county? And so when you start to add all of these extra entities, for instance, if you have someone that lives in Davidson County, but they have a charge in Sumner County, the DA in Davidson County and Sumner County has to be served. Under this legislation, the DA in Davidson County has to be served, the DA in Sumner County has to be served, the AG's office has to be served, as well as the Secretary of State. I mean, that's $100 in addition to what the filing fee is going to cost a person. Now, you may think $100 is not a lot, but for somebody that is barely making it around here, $100 plus in Davidson County, the filing fee is $159. That's $250+ just to file a petition. And now we're talking about judges have the discretion. So the person can spend $250 and the judge can still deny it, right? I mean, like, there's a lot of things that's wrong with all of the extra stuff that's been putting in here. And as I mentioned in my testimony, there are ways that this can be fixed, but putting all of this into the court system with and doing it just so quickly. And I understand that there were conversations in the summer and the fall about this. However, we're talking about uprooting a process that has been in place for 20 years, putting it in the court system, giving judges discretion without even bringing all of the parties to the table and to figuring out if this is something that's even going to be like efficient, and to see if this is even something that's going to be workable for all the parties involved.
Thank you for that. Representative Powell.
Same question, Ms. Haynes. How would a person go about proving that they have, they're up to date on restitution, child support? I mean, how does somebody go about proving beyond a preponderance of evidence they meet this standard?
Yeah, so that's a good question. Thank you for that. Because right now, the person doesn't have to do that. The burden is not on the person to do that. Right now, it is just a simple form that is filled out, and that's what people do. But under this now, what people will have to do is that they will have to go to the clerk's office, and they will have to get something that says that they have paid off their court costs, so they've had it waived, right? So going back to my situation that we're talking about with somebody that has that lives in Davidson County, but had a charge in Sumner County, that person's going to have to go to Sumner County clerk's office, and they're going to have to get that, right? And so then they're also going to have to get, all of these certified judgments, because I think it says that they have to list every single felony offense that they have. So that could require a person to go to all types of different clerk's offices around the state, if that's the case. And then to prove restitution, that gets a little tricky, because depending on which county you're in determines who has that information. Here in Davidson County, they have it. However, in other counties, they don't. So I can't go to the Davidson County clerk's office and ask them to give me something showing that I've paid off my restitution, because guess what? The Davidson County clerk's office doesn't have that information. TDOC has that information, but you go to these other counties and they may have it, they may not. Now, how does a person prove child support? That is a good question, because we don't deal with that right now. We do not deal with DHS at all when it comes to getting someone their voting rights back. That's not even on the form that TDOC does. That is something that the Elections Commission does on their own. So now you're asking everybody that's involved in this process to figure out how this works when we have never done this. And then to think we have over 470,000 people that are disenfranchised in this state, 360 living in the community. You're asking, and even if you have that number, you're asking all these people to ascend up on the court clerk's offices, to TDOC's offices, to DHS to get this information.
One last question, and it's directed at you, but other members of the committee could also, or the panel could also respond. But it sounds like there was a lot of negotiation on this bill. Representative Holsey's referenced that. Leader Lambert mentioned that. And now it's kind of all fallen apart. I guess in your scenario, what would the ideal bill look like? If you don't like this bill here.
So, and I'll just say, with working in the current statutes that we have, because my ideal bill is that people would never lose their voting rights to begin with, but but working within what we have right now, I think that there's a couple of ways that we could do this. First, we could keep sections 1 through 5, right? I mean, we all agree that sections 1 through 5 is what is needed, separating gun rights from voting rights. I personally don't think that judges have gotten it wrong in the court system. I mean, multiple judges have all said that you can get your full rights of citizenship back, even if you cannot get your gun rights back, because it is not a restorable right. There's Supreme Court cases that back that up, all of this kind of stuff. However, we can alleviate that confusion with just going through with sections 1 through 5, right? And then we can still have folks to do the certificate of restoration, what people have always done. That is the simplest fix. But if we just want this to be in the court system, another way that we can look at this is at mirroring this through the expungement statute, right? The expungement statute, expungement is not a right, okay, like voting is. However, expungement does not have preponderance of the evidence. Expungement is just a presumption, right? The expungement statute, you're only serving the district attorney. You're not serving the district attorney and the AG and the TBI and all these folks. No, you're not doing that. You're only serving the district attorney. So that's what we could do here. That's what's always been done. Now, if the Secretary of State, who is wanting this in court, and there will no longer be a certificate of restoration, if he just wants to be involved in this, there can be a certification that he can fill out the same way the TBI does when it comes to expungements. Now, this certification is not the end all be all. If the individual doesn't agree with it, then the court can have a hearing and then the court can decide. However, if the certification comes back and says, hey, okay, this person meets the requirements, then the judges don't have to have a hearing. The judge can just sign that order, send it over to the elections division, and then they can also send it to the individual. So those are two things that, I mean, looking at the expungement statute, we know that it works, right? Nobody has challenged the expungement statute for, constitutional violations of due process or, equal protection, which if this was to go forward, I mean, my gosh, this is riddled with all of those constitutional violations as well. Because again, we're talking about fundamental rights and we're talking about being in the court system. So those are the two things. The simplest thing is amend this sections 1 through 5 of this. That's what they were going to do last year. Everybody that supported it last year.
Any other questions for our guest? Seeing none, thank you all for being with us today. Next, I have on my list Janet Kleinfelter, Beth Henry, and Mark Goins. We control it up here, so just be patient. Thank you. Now, introduce yourself for the record. You'll have 3 minutes for comments, both of you, and then we will open it up for questions.
All right, Mark Goins, Coordinator of Elections. Beth Henry Robertson could not be here today. Janet Kleinfelter, Special Counsel to the Division of Elections. First, I do want to thank Chairman Holsey and Michelle Fogarty. You talk about yeoman's work. They really put it in. And I know that Representative Russell's a co-sponsor, but the work that the folks put into this is unbelievable. I do want to address a few things. I'm not here to, the prior panel, the first speakers really spoke in favor of the bill. If you listen closely to what they were saying about a streamlined process. And if there's any confusion, and I would argue that the confusion may be caused by others, but if you look at the streamlined process, this is it. And currently, let's talk about what the current statute, what the current process is. Folks have to go to court now. This doesn't change that. Folks have to prove court costs. They have to prove that they're current on court costs, that they paid them, that they paid restitution, that they're current on child support. This doesn't change that. Folks have to do that now. This doesn't change any of those things. And I don't know where the amendment came from or some language came from, but I want to point this out. We heard a lot about, a poll tax and those things. The fact is someone forfeits their rights. That's not my words. It's the Supreme Court's of Tennessee's language. It's the statute's language. But on page 8, section F, Chairman Holsey listened to that argument and he put language in there, and I'll read it to you. All costs for proceeding under this part must be paid by the petitioner. However, the court may waive the cost if the defendant is indigent. And you look further in the bill, the ALC is supposed to make it easy. They're supposed to develop a petition. They're supposed to even draft sample orders. So some of the things you heard is more about the current process that this seeks to redress. So I think that this is one of the best bills that you'll see before this committee this year. 100% support it. Be happy to take any questions that you have.
Thank you. Go to Ms. Janet.
Janet Kleinfelter. I just reiterate what Mr. Goins said. I'm here to answer any questions that you have from a legal perspective. I do want to point out that the bill does not require that service of process be made on the Attorney General's office, the District Attorney in the U.S. Attorney's office, or the Secretary of State. In fact, the bill requires that the clerk of the court simply give notice. So there is no any additional financial cost that is imposed upon a petitioner by the cost of service of process. And I'm available to answer any questions that you might have.
Thank you very much. First on my list is Representative Powell.
Thank you. I guess if you could speak to how moving this to filing a petition in the court rather than administratively makes this easier.
So that's relitigating Falls v. Goins. Right now, it has to go to court. So this doesn't change that. Currently, under the process, you have to go to court. If this bill passes, you have to go to court.
Isn't there a second court process, though, to get these rights restored? So you're having to, there's additional fees and other things. I mean, you're not, I know you made the argument that you've got those fees you pay initially, but it seems like you're also now paying additional fees to now prove just this. Can you speak to that?
No, I mean, and that's what I'm saying. That's what's interesting about the arguments we just heard. Currently, you have to get a court order to send it to our office. This still would require a court order. Prior to Falls v. Goins is the different path that you're speaking. We're not here to relitigate Falls v. Goins. I mean, that's the Supreme Court of the state. That's the law. So you're either going to court if this bill passes, or you're going to court if this bill don't pass.
One other question. The person referenced make this similar to more like the expungement process. Could you speak to that? Why not make it easier for those, similar to the expungement process versus this fully involved process that this bill seeks to create?
As far as, I mean, that's a legislative decision. I will say that we've seen more expungements come our way over the last couple of years. So we are seeing that the legislature has made some movement that way, but that's not what this bill does. This bill's separate from that. It's not the content of this legislation.
And I will add to that. I don't know that the expungement process would work for individuals with out-of-state convictions or convictions from federal courts.
That's true.
Any other questions for our guest? Seeing none. Thank y'all for being with us. We're going to go back in session. Okay. Representative Powell.
Thank
you. I guess thank you. Just allow the chairman to kind of respond to what you heard. If I heard two very distinct, I guess, sides here. Those that are representing and have adjudicated and helped people go through this process now, which seemed, to me, it makes sense. I mean, and let me back up and say, I do appreciate your work on this, and I fully support separating voting rights from gun rights. So I like that portion of the bill, those sections. But I think to me, looking at this, it seems like, based upon the testimony we heard, it's going to be a much more involved and complicated process and keep more people from getting their rights. So could you speak to respond to some of the different sides that we heard and what you think of that?
Yep. Thank you. I don't see it that way at all, actually, because it's one streamlined system. You have to show the court that you've paid restitution. You have to do that now. You have to show the court that you're up on your child support now. You have to show the court that you haven't committed any other crime that would keep you from losing your ability to get your voting rights back. Those things are in existing law, and I don't see them as being nefarious like that or as time consuming. I think it will take a little bit of time for the court system to get the forms out to everybody that they go to. But once that starts, I think that process will be fine. And you have to sign that this is a true statement. But the preponderance of evidence to me is not a big issue, because the preponderance of evidence is satisfied when you show that you have paid restitution, you've paid fines that are punitive, that are part of the sentence, and that you're current on child support.
Thanks for that answer. One other thing I wanted to ask you about. So why in the bill if you could talk about the legislative intent, because the coordinated elections reference that this was more of a policy decision for this one component of the bill. but why are we giving, say, a notice to the coordinator of elections involving the AG? And then to me, it ultimately, this is up to a judge to decide the final say. We're moving this from a completely administrative process where someone meets to now taking it to a judge's opinion. Could you speak to why that's in the bill?
I think when this came up in the summertime in discussions, there were issues where the commissioner of elections might have a reason to object or not be shown the proof that these things have been satisfied. But he doesn't, as I understand it, he didn't have standing actually to bring this in front of a judge himself. So we looped the AG in as the mechanism for him to use, if I'm remember correctly. There's a lot of the things we discussed, but I think that's it. You can check with your legal assistant who knows every bit about this bill, if you'd like to ask her that question.
Any other questions? Leader Lamert?
Chairman, thank you. And I hope that the objection to this bill are not an example of better being the enemy of good. I think this is a good step forward. I know it's not as far as some very passionate advocates would like to go. But again, Chairman, I applaud you for doing yeoman's work here. And it was stated earlier, and I was following the testimony from outside and from when I was in the room. And I think there's some conversation a little bit about the expungement process. I mean, this is remarkably similar to the expungement process. I mean, you go to the clerk's office, they have forms that you get. I've done no telling how many, probably hundreds, if not thousands of expungement petitions for clients. And you file that with the court. The district attorney's office is noticed. They have an opportunity to object. The court rules on it. It's ordered. Then it goes out to an administrative agency, in this case, TBI, and they remove it from the record. I mean, it's to me, is remarkably similar to what you have formulated here. And what I really like about this is once the judge rules, unless somebody appeals, that's that. I mean, there's none of this administrative back and forth and lawsuits here, there, and everywhere. It's just somebody knows, hey, look, they presented their case to the court. The court has ruled in their favor. And unless somebody appeals and has good reason to and can win an appeal, it's done. And that person just gets their rights back. So I applaud you, sir. You've done a phenomenal effort here. I know it's not as good as some other folks that I respect would like it to be, but it's a heck of a lot better than what we have on the statutes now. So just want to say thanks.
Representative Atchley.
Call for question.
Questions called. Any objection? Seeing none. We're now voting to send House Bill 445 as amended to full judiciary. Does anyone wish to change your vote? Madam Clerk, please take the vote.
Mr. Chairman, you have 7 ayes, 2 noes.
The ayes prevail. House Bill 445 as amended moves on to full judiciary.
Thank you, Mr. Chairman. Thank you, committee.
Item number 6, House Bill 305 by Representative Gillespie. We will roll to the hill. Item number 7, House Bill 478 by Representative Butler.
Motion.
You are recognized. There is an amendment, code 6353 by Representative Scarborough on this. Representative Scarborough, you're recognized on the amendment.
My amendment rewrites the bill, revises the offense of possessing a weapon on the property that is properly posted to prohibit such possession, such as offense only applies if the individual intentionally or knowingly possesses a weapon where not authorized. Amendment creates an affirmative defense to prosecution for the offense of if upon the request of the individual authorized is controlled access to the property. The individual immediately leaves the property or stores the firearm in the personal vehicle in accordance with state law. My intent in the motion was to support the sponsor's intent to prevent the individual who accidentally carries into an unauthorized area from being charged with a crime. That's my intent. However, it provides language to hopefully discourage the intentional offenders from causing issues in the areas that have been properly posted. I did this in a rational state of mind as a 35-year law enforcement officer, and keeping in mind the law enforcement that have to deal with these issues on the street from time to time, and trying to discourage and any confusion that posted on business owners and or law enforcement and those illegally carry. I think this helps those that are lawful carrying members. I respect the Second Amendment. However, we do have an issue where we have those that intentionally try to cause issues in the areas that are posted for unlawful possession. And that's the intent of my amendment.
All right. Sponsor, bill sponsor, comment?
Thank you, Mr. Chairman. I said I'll yield to the will of the committee on this.
All right. Discussion on the amendment. Question has been called on the amendment. Any objection? Seeing now none, we're voting now to adopt Amendment Code 6353 on the House Bill 478. All those in favor say aye. Aye. Those opposed? No. The ayes prevail. You adopt. If you wish to be recorded as a no, please see the clerk. All right. So we're on House Bill 478 as amended.
Mr. Chairman, I believe the sponsor of the amendment explained the amendment. And so from there, I'll answer any questions.
Questions for the sponsor? Seeing none. Any objection to the question? Seeing none. We're voting to send House Bill 478 as amended on the full judiciary. Does anyone wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 7 ayes, 1 no, and 1 present not voting.
The ayes prevail. House Bill 478 is amended, moves on to full judiciary.
Committee and Chairman.
Item number 8, House Bill 1204, Chairman Kumar, not here. Roll to the Hill. All right, we're back on item number 5. Or excuse me, item number 3. House Bill 883 by Chairman Todd. He is not here, so we will roll him to the Hill. All right. Item number 11, House Bill 36 by Vice Chair Davis. Your recognizer is Amendment Code 6202. Do you wish to proceed with that amendment?
Yes, Mr. Chairman.
All right, you're recognized on the amendment.
Thank you, Mr. Chairman. And so what this legislation does is it helps with geriatric inmates. What we're wanting to do is those inmates that are within a year of their life left and they have only one sort of daily activity that they're not able to perform, such as toileting, eating, mobility issues, that they be allowed to present to the a judge and then also go into possibly for parole. Also, we're looking at changing any of those geriatric inmates from 70 years old to 55 years of age. With those inmates and reducing that age number, they have to have served a minimum of 10 years in custody. Currently, it's 5 years. Also, they cannot be serving a sentence for any sort of violent sexual offense, a conviction of first-degree murder, or facilitation of first-degree murder. Also, they cannot be serving a sentence for imprisonment with life without the possibility of parole. Also, they cannot be released into the community without a substantial risk, and so that inmate will commit a crime. What this does is this allows that inmate or someone based on their behalf petition the court to review. It has to be the court of the jurisdiction where that inmate was convicted. That judge reviews whether or not the risk, they have met all of these qualifications and they're not going to be a risk. Then that judge also makes a notification to the Board of Parole for them to review. So there's several steps in order for that inmate to be able to have that review of that risk assessment. TDOC, then the judge, then the Board of Parole. And with that, I stand ready for any questions.
We are on the amendment 6202. Questions been called on the amendment. Any objection? Those in favor of adopting Amendment Code 6202 on the House Bill 36, say aye. As opposed? Ayes prevail. You adopt your bill as amended. Do you have anything else on the bill? There's amendment makes the bill?
Yes, sir.
All right. Questions for the sponsor, Leader Lambert?
Mr. Chairman, there was an amendment that was filed late, I think, by the sponsor of the bill, coded 6437. And I know we're getting long in the tooth on this particular committee. It changes one sentence that I think was just an inadvertent inclusion, where the amendment that she has says that the court shall not hold a hearing on this, but the amendment that was late filed changes that one sentence. We can check with legal, but I think it just changes the one sentence to say that the court basically is not required to hold a hearing. So it just leaves it up to the court's discretion. Mr. Chairman, I would move that late filed amendment be considered by this committee.
All right, that is a proper motion.
Thank
you. It has been seconded in Amendment Code 6437. We will now be voting for consideration. Do you have a question?
I haven't seen the amendment. It's not on thing, so on the dashboard.
Why don't we'll go out of session. We'll hear from Legal Services. Legal, if you would, explain what that change is, if you can.
Word got done in another committee, so let's be consistent. If it's not in the system, why are we asking to be voted on something that we haven't even looked at?
Legal Services, you are recognized.
Michelle Fogarty, Office of Legal Services, draft number 6437 under section 2, subsection C, deletes the language from draft 6202 that says the court shall not hold a hearing on the petition. It deletes that sentence and replaces it with this subsection C does not require the court to hold a hearing on the petition.
Any questions for legal while we're out of session? All right, seeing none, thank you. We'll go back. We're back into session. Where we are is there's been a motion to consider the amendment. So we would have to vote to consider. We would not be voting for the amendment for adoption. We will only be voting for consideration, and then the sponsor of the amendment would then present the amendment, the untimely amendment. That is correct. We're now voting for consideration of the untimely filed amendment. Those in favor say aye. Aye. Those opposed? The ayes prevail. Now we are in a posture where you can explain Amendment Code 6437.
And I appreciate that. Thank you very much for giving me that grace and allowing for that amendment. What I wanted to ensure was that judge had the judicial discretion to have a hearing. So with the victim notification, that way, if the victim would like to come and testify to that judge, they can. And so that's something that the judge would have the discretion to determine. They can look and review if that inmate, and they can present the report to the Board of Parole without a hearing, or they can determine whether or not they'd like to have a hearing. It's just, I wanted to make sure that judge had that discretion to do so. And the way that phrase was written, it didn't allow for that.
Let me get us back in the right posture. I'm sorry, I jumped the gun. We also need a motion and a second on the amendment to hear the amendment now that we have brought it forward to consideration. So there's a motion and a second. I'm sorry. Now we're back on the amendment. You got anything else?
I stand ready for any questions, and I would appreciate a vote.
I've got Chairman Farmer has a question or comment.
So, and thank you, Mr. Chair and Madam Vice Chair. So as I understand it, all this amendment does is allow the court that had the jurisdiction in the original sentencing to just determine whether or not they need a hearing on this. So it's just something they feel comfortable with, and this court would just pass on that. If it's something that's controversial, they may not feel comfortable with, they can have a hearing, they can call the victims in, they can hear from the victims. Everybody would have their day to express their views and opinions on this, and then that judge would then decide whether or not this moves forward to the parole board for a secondary hearing.
Correct.
Okay. Thank you, Mr. Chair.
Leader Lambert.
I just want to say, I mean, that was one of the biggest failings I kind of saw in the legislation. I mean, if we're going to be talking about somebody who's committed a crime, being found convicted of that crime, and been found guilty of that crime, and then they've been sentenced, they've gone off to prison, and they're coming back to court, I think it's critical that the victims or survivors' families at least have an opportunity to be heard. I mean, if this is going to happen, then they need to have an opportunity to be heard. To have a sentence in here that says that there's not even going to be a hearing on something of this serious and to preclude them from even being heard in court seemed to me to be a miscarriage of justice. So thank you for at least considering the amendment on this and for bringing the amendment forward. I think it makes it a better bill.
Thank you.
Any other questions for the sponsor? We are on the untimely filed amendment. Any objection to the question of adopting the untimely filed amendment? All those in favor of adopting Amendment Code 6437 on the House Bill 36, say aye.
Aye.
Those opposed? The ayes prevail. You adopt. Stand by. Okay. We're on House Bill 36 as amended. Questions for the sponsor? Chair Lady Littleton.
Thank you, Mr. Chairman. I just want to clarify that did the victims get the choice, like if to go before the judge or not? They will be allowed the choice. I was thinking it was just the judge that would make that decision, but the victims can also help with that decision. Is that correct?
Chair Lady Littleton, yes. That was one of the whole points and purpose of making sure that that victim was notified of that process, that inmate had wanted to be submitted for parole.
Thank you. I just wanted to clarify that. Thank you.
Any other questions for the sponsor? Seeing none, any objection to the question? Seeing none, we're voting to send House Bill 36 as amended to full judiciary. Does anyone wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 8 ayes, 0 noes, and 1 present not voting.
The ayes prevail. House Bill 36 as amended moves on to full judiciary.
Thank you, Mr. Chair. Thank you, committee.
Representative Hardaway, you in the room?
Yes, sir.
It's good to see you. We're going to skip down to you here. Item number 19. House Bill 358. You have a motion and a second. You're recognized on this.
All right. Mr. Chairman, I'm trying to find out how to get back into my stuff here. All right. All right, thank you, Chairman. Thank you, committee, for your patience. Following the arrest of a defendant for any of the following offenses, this bill requires a court or magistrate to order the defendant to wear a global positioning monitoring system device as a condition of bail, unless a court or magistrate finds the offender no longer poses a threat to the alleged victim or public safety. Quite simply, this expands upon what we've already proven to be a favorable way of stopping those who are accused. There's probable cause that they did the crime from committing additional crimes against the same victim and additional victims. If you look at the list of crimes, it includes domestic assault, which we already have included in current statute, but it also goes to reckless driving. That's in order to address those who are out on bond for drive-by shootings, drag racing, the second offense or subsequent offense constituting burglary or theft. Those are for these folks who are breaking into cars, stealing weapons, and doing it also while they're out on bond. We can keep up with them. We can do two things for sure. One is to know if they were near any crimes that occur while they're out. And the other is it keeps the criminal gang activity down because nobody wants that individual around to commit additional crimes. With that, Mr. Chairman, I'll await questions and a favorable vote.
Thank you for that explanation. First on my list is Leader Lamberth.
Now, you know you're my friend and you bring this bill just about every year, and it's a good bill.
I
However,
think so.
we just started with a bill that the chairman carried last year and you supported, and it followed up on a bill that you've carried many times on aggravated domestic assault. And I think the court system is still working out how to do that as a mandatory GPS. Now, I fully support GPS as a bond condition. I think more magistrates and judges should utilize that. But to require it right now at this juncture, while we're still figuring out what we required last year, I think would be a bridge too far. And so I want to make this happen. At this point, with respect to the sponsor, would make a motion for a summer study. And the only reason for that is I know there's another bill we're taking up in a little bit that deals with changing the bill we just did last year on GPS. And I don't know how these would wind up lining up together. So, I mean, we've got the aggravated domestic assault that's working well. We've got a bill this year to kind of adjust that to make sure it continues to work better. Now to expand it into all of these misdemeanors. I'm afraid we're going to at some point overwhelm the court system when we're trying to get this implemented. And you worked on this for years. And so trust me, it hurts my heart to even make a motion for summer study because you've worked on this for a long time. But I just feel like we got a little more work to do on this one. So that would be my motion, Mr. Chairman, with respect to the sponsor.
All right. Representative Hardaway.
Thank you, Chairman. And I would thank the leader for the work he's done. He's being modest in helping to shape this and other pieces of legislation, which have saved lives. What I would ask, if we're concerned about the impact on the current statute on domestic violence and collecting that data, there are some other things in here that I think are just as important in collecting data. And those are things like these car burglaries where we're getting guns that are being put on the streets. I think the drive-by shootings with the reckless endangerment. So I would ask the leader, since we have one or two meetings, or is this it, Mr. Chairman?
This is it, Mr. Representative.
Well, in that case, I thank the leader for the summer study. I was going to ask if we could just roll it down to the next meeting and take some of these out and reduce the impact on the court system.
All right. Leader Lamberth.
Thank you, and thank you for that. And Mr. Chairman, I know in years past, we have sometimes sent bills to summer study that was a black hole that they went into and never reemerged. I know we had a bill just earlier dealing with search and seizure issues and search warrants and all of that. And I joined the chairman in requesting of the speaker that we really do call this committee in and/or Chairman Farmer's committee to really look at these issues. I mean, this issue of GPS has been around for years. It is worthy of a deeper discussion where you, Mr. Chairman, may spend an entire day just on GPS and how it's being implemented so that we can improve safety. We haven't done that in a long time. And it's probably, in my humble opinion, time to do it. So that'd be up to you and Chairman Farmer and the speaker. But I certainly would support that. And I know these committee members this Judiciary Committee is a working committee. And so I know we're all eager to come in and work even in the summertime. So just my comments on it on the motion, Mr. Chairman.
All right. Thank you. And I'm willing, certainly willing to write a letter to the speaker and ask the members of this committee to sign on to that letter requesting a summer study on this. I know the Senate did some work back over the late summer, early fall about it involves some GPS and some things like that. So I'd be interested in seeing us do one over here. So,
Well, I thank you for that, Mr. Chairman, and I'll wait the will of the committee. And I can tell you, once we get this going, you'll see the lives are saved. I've actually had, one of the things that got me started on expanding it was that we had a couple of lives that were lost to individuals who were out on bond for violent crimes. So I'm looking forward to working with all of the committee, Chairman Farmer, for summer study.
all right. Well, thank you very much. Members, we had a motion for a summer study. It was seconded. So if that's the proper word, I don't know. Seconded, maybe. There's no T in that. So we're now voting to send House Bill, without objection, we'll vote to send House Bill 358 to summer study. Does anyone wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 9 ayes.
House Bill 358 will go to summer study. Item number 20, House Bill 625 by Representative Hardaway. You are recognized. There are no amendments. Please proceed.
Thank you, Chairman. House Bill 625 creates a rebuttable presumption that a person with mental illness or serious emotional disturbance meets the standard for emergency detention and examination if the person was charged with certain offenses. And those are going to be those offenses where the convicted, if the defendant, if convicted, would be required to serve at least 85% of the sentence imposed. This comes from a real life situation also, where we had a judge that said, hey, I want to see if you're competent, I want to see if you're dangerous, but he let the guy out on bond anyway. And he ended up killing someone while he was out. So that's the purpose of this bill. With that, I'll entertain questions or a favorable vote.
Thank you for that explanation. Members, questions for our sponsor? Seeing none. Any objection to the question? Seeing none, we're voting to send House Bill 625 on to full judiciary. Does anyone wish to change their vote? Madam Clerk, please take the vote.
Mr. Chairman, you have 8 ayes, 1 present not voting.
The ayes prevail. House Bill 625 moves on to full judiciary. I know, Representative, you got some other bills, but we are out of time. We've got to give up the room. So,
Sir, I
members,
thank you for this.
we are going to recess until tomorrow morning at 9 a.m.